Hi, this is Quintella Griffin with Ward's Realty. I'm a certified real estate probate specialist, and today I will be doing a presentation on how to avoid probate by a transfer of deed upon death. Thank you. Disclosure and disclaimer. I'm not a lawyer. The information provided in this presentation is for informational purposes only. Each state varies. You should seek legal advice from an attorney and/or do your research on this topic. I have to make this disclosure because I don't want anyone to assume that I'm a lawyer. So again, this information is provided for informational purposes only, and you should seek legal advice and/or do the necessary research to find out additional information on this topic. Thank you. So let's discuss what is a TOD. A TOD is a simple revocable transfer on death deed, also called a TOD deed or beneficiary deed. It is a simple way to leave your residence to your heirs without the need for probate. The current owner or transferor names the intended heirs and beneficiaries. The deed has no effect until the transferor dies, when the beneficiaries receive. So this deed does not take effect until actually someone has to pass away. What does a TOD do for you? You can rest assured your last wishes will be executed. Give you a peace of mind. No lost wills, no lost living trusts, no transfers by fraud because the beneficiary is on the deed, no contesting the will or living trust. It's a win-win situation depending on your circumstances. And here's the funniest part. Laughing in your grave for people waiting on you to die who think they are getting your property. Avoid probate by a TOD. A TOD is an inexpensive way to deed your house to your kids or anyone without probate. The revocable transfer on death TOD deed, also called a beneficiary deed. TOD deeds are now legal in 27 states, including California. Revocable transfer on death deeds took effect in California on January 1st of 2016. In other states, these deeds may be referred to as a ladybird deed. So if you do not live in California and you are looking for a deed similar to this deed, you might want to do your research on a ladybird deed. Avoid probate by TOD. By filling out a simple form, notarizing it, and recording it with the county recorder's office, you name a person or people to receive the property upon your death. The beneficiaries, unlike a joint tenant deed, the TOD deed can be revoked if you change your mind. TOD instructions. Here we have the simple revocable transfer on death TOD deed. This is how you create the TOD deed. And after you complete the form, you're going to have to sign a notary acknowledgement and have the document notarized. Why is a TOD deed better than adding your kids or beneficiaries as joint tenants? Well, let's take a look at this. Clouding title if done incorrectly. Until now, a popular way to avoid probate was adding your child or children to the deed as joint tenants. While this works, it can cause serious problems, which the revocable TOD avoids. One of the problems joint tenants can cause is clouding the title if it's not done correctly. It is just one of the problems it can cause, and there are many more. Why is a TOD better than adding your kids or beneficiaries as joint tenants? You're keeping control of your property and it delays ownership. You can revoke the revocable transfer on death deed at any time. The joint tenancy deed makes your intended beneficiaries full legal owners immediately. Therefore, you cannot remove the kids or beneficiaries unless they sign off on title. Why is a TOD deed better than adding your kids or beneficiaries as joint tenants? You are not responsible for kids or beneficiary debts. Joint tenants can cause problems selling or refinancing. Your kids' debt could cause liens and you can't change your mind. The beneficiary or TOD deed does not give the kids an immediate rights to the property, so it avoids these problems. When might a joint tenancy still be the right choice? If you intend to give other person current ownership interest, a joint tenancy lets you do that, but still retain an ownership interest yourself. For example, you might agree to add them if they are helping you pay for the property, or if having them on title helps with getting a loan, or if they are actually living there and you want to make their ownership official. What if I change my mind? You can revoke your TOD deed at any time by notarizing and recording a revocation of revocable transfer on death deed. This form is very similar to the TOD deed itself. It must be recorded prior to your death to be effective. TOD revocation form instructions. This is the form that you use to revoke a beneficiary and/or if you want to change a beneficiary and remove it and replace it with a new beneficiary. It has detailed instructions, and at the end of this presentation, there is a link that will take you to this form that you can download. How do my beneficiaries receive the property? If you are the only owner, or if your co-owner has already passed away, your heirs receive the property. In order to put their name on the title, they notarize and record a simple form called Affidavit of Death of Transferor under TOD Deed, along with the death certificate. It's just that simple. How do my beneficiaries receive the property? Continue, and this is very important. Note, if you co-own the property as joint tenancy or community property with rights of survivorship, the other owner receives your share of the property upon your death. The TOD deed has no effect unless you outlive your co-owner. That's why co-owners have to sign separate TOD deeds if they both want the same beneficiaries. Affidavit death of transfer. Once the homeowner or property owner passes away, this will be the form that you use to transfer the property into title into your name. So you will fill out this form, you will attach to it a death certificate, and you will record it, and once you do this, the property will become yours. At the end of this presentation, there is a link that will take you to this form for future use. It's crucial to fill out and record the TOD form correctly. The TOD requires very specific language to be effective. If any requirements are missing or incorrect, your deed may be invalid or may have unpredictable results. Requirements for TODs. Pay close attention, please. Number one, all owners must fill out their own TOD deeds. This means that a married couple, for instance, must fill out and record two separate TOD deeds. If you live in a community property state, that means you only own 50% interest in the property. Or if you hold an interest in the property, you can leave your interest in a TOD, but not the entire 100% interest. Number two, each form must be notarized. Number three, the TOD form must be recorded within 60 days of being signed and notarized. Number four, the property description and your name must match the title documents, usually your current deed exactly. You can obtain this information from Exhibit A on your grant deed, deed of trust, or whatever instrument you recorded. Five, you must list the beneficiaries by name and state the relationship to you, such as spouse, son, daughter, friend, etc. List of forms. These are the forms that you're going to need to complete a TOD or to revoke a TOD or to transfer the property into your name after the person has passed away. Number one, transfer on death, TOD deed. So you're going to use number one to create the TOD, and below is the link that can provide you with the deed to fill out. Number two, transfer on death deed, revocation. This form is used to revoke a beneficiary. So say you have a beneficiary that you decided that you don't want to leave your property to, or you just want to make a change. You would use this form to revoke the beneficiary, and then you would actually fill out a transfer on death deed and record the new beneficiary. Number three, affidavit of death, transfer on death deed. So you would use this after the person's death. So you will need to attach a death certificate to this form to transfer title from deceased to beneficiary. And it's just that simple. It's just that simple. So note, you may revoke the TOD by using form number two, which I just indicated. This will allow you to remove a beneficiary or make changes. Thereafter, you record a new TOD form, number 1, for the new beneficiary. Alert, words of wisdom. I'm sharing this information with you because this is something that I often see in real estate, believe it or not, especially dealing with probates, trusts, or inherited properties. Warning, how people are stealing beneficiaries' properties legally. Yes, legally. This is not just going on in California, but all over the USA. In real estate, I have seen some unbelievable acts committed by people who transfer properties to themselves because to become beneficiaries who should never be beneficiaries in probate. Unsuspecting pastors, yes, pastors who abuse God and church members to steal their members' properties. Greedy heirs, hustlers who hang out at the probate court looking for a come up. People who make a living reading the obituaries looking to become the missing heirs on estates that have no heirs or if they want to become an heir. I've even seen some attorneys that have done wrong to their clients in probate for the love of money. Yes, the love of money will cause people to do wrong things. I've received emails asking me to pose as an heir because I have the same last name and the state has no heirs. No lie. I'm alerting you so you can protect yourself and heirs. Don't take my word for it. Do the research. Google it. Do legal research. Here's the link to petition for probate in California. So I've listed here the link that will take you to a petition for probate so you can actually see the language that I have here contained. Look at page 3 of 5. Question 5B. Below is the language. So here we have the language here. B. Decedent was or was not survived by a stepchild or foster child or child who would have been adopted by decedent but for a legal barrier. See Probate Code section 6454. So this is how a lot of people use this language, which is legal to get into probate court, that should not be a heir. Now, people are abusing this part of the probate code, and they're actually using it to actually steal people's properties. And I took note of this. And this is a form. This is not an optional but mandatory file to file probate. This is an actual form that is mandatory. So you can't file probate without using this form. See the bottom left-hand corner. Anytime you have a judicial council form, always look at the bottom of the left-hand corner and you'll see if it's mandatory or if it's optional. This particular form is mandatory. Fraudsters are simply filing probate by jumping in and stating that they would have been adopted by decedent but for a legal barrier. This is the language that they're using. This might seem crazy, but it's true. Heirs will have to defend themselves against this fraudster or many fraudsters by hiring an attorney. Now you're incurring attorney's fees. Sometimes people don't have money to defend themselves and people end up stealing their properties because they can't defend themselves. Since I saw this was going on, since I became a real estate agent, I decided, I wonder how I could combat this. So what I did was I had both of my parents prepare declarations that state they never had any intentions to adopt any children, and me and my sibling are the only children that they had. Here's my recommendation. Do not allow anyone to pretend to have a relationship as a family member that will take advantage and become an heir. Read Estate of Louis Joseph, decedent, Kim Barman Smith, petitioner and appellate versus James C. Joseph, objector and respondent. This is a real live case. You may find cases just like this at law.justa.com. Thank you very much. I'm Quintella Griffin, Smart Agent. Agent Q, sharing is caring. Thank you for watching my presentation. If you are looking for a listing agent who specializes in probate sales, trust sales, inherited properties, give Quintella Griffin a call at 925-237-1310. I'm not just an agent who puts a sign in front of your property, but I am an agent who is smart that cares about your well-being. Need a referral to a good attorney? Give me a call or email me at agentqrealtor@gmail.com. Thank you. Videos to help you learn. Below are 5 links that will take you to various videos to answer some of your questions and more details, and for your own research on the process of TODs.